No. Thank you.
John. Oh, you want to? No, that'd be good. People to find out about that. Don't do it. Ain't gonna do it. Right?
What are we talking about?
Okay, we're going to start the next regular meeting for the Public Financing Authority, and we're called to order. Any closed sessions?
Chairman, there are no items for closed session.
Any additions to the agenda?
No, Mr. Chairman, no additions.
Public comment?
Public comment. The first 15 minutes of each regular session is set aside for members of the public to comment on any item within the jurisdiction of the board but not appearing on the agenda. Items presented under public comment may not be discussed or acted upon by the board at this time. For items appearing on the agenda, the public is invited to comment at the time the item is called for consideration by the board. Any person addressing the board under public comment will be limited to a 3-minute presentation to ensure that all interested parties have an opportunity to speak. Any handouts to the board must be submitted to the chief clerk of the board for distribution to the supervisors. Anyone addressing the board is asked to print their name clearly on the speaker sheet at the podium. Also, all persons addressing the board may state their name and county residence for the record.
Thank you. Here we go, team. Any comments from the public? Hearing none. Item number 4,
4, approval of minutes. Consideration of approval of the public meeting minutes for September 19th, 2017.
The minutes. Got a second? Roll call, please.
Call for the vote. Supervisor Frazier?
Yes.
Supervisor Rodriguez?
Yes.
Supervisor Wheeler?
Yes.
Vote passes 3-0 with 2 absent. And Chairman Wheeler, I was going to announce earlier in the meeting that Directors Mahill and Talbert are absent today.
Okay. Thank you. Okay. Item number 5.
5, Community and Economic Development Department, Planning Division, Infrastructure Financing Plan 2018-1 and Enhanced Infrastructure Financing District, Tesoro. A, hearing to consider adoption of a resolution of the Tesoro Viejo Public Financing Authority forming an Enhanced Infrastructure Financing District and approving Infrastructure Financing Plan 2018-1. B, hearing to consider adoption of a resolution of the Tesoro Viejo Public Financing Authority announcing its intent to issue bonds for Enhanced Infrastructure Financing District number 2018-1.
Thank you. Here we go.
Thank you, Mr. Chairman. Matt Treber, Community Economic Development Director, again with Dale Bacigalupi, County Council, David Tossig of David Tossig and Associates, and Jamie Bax, Senior Planner from my office. We do have a brief PowerPoint presentation as well on this item for the board's consideration. On August 22nd, that was the first action taken in relationship to the Tesoro Viejo Enhanced Infrastructure Financing District. That's when the board created the Public Financing Authority, your board here today. On the September 19th, and it is, I would note that there is an error, a typo in the infrastructure financing plan on page 1 of that document, or 16 of the backup. We did reference that action of April 17th, 2018. That should have been September 19th of 2017. So my apologies to the board for that. And then the board approved this infrastructure financing plan on June 12th of 2018. Again, a map here showing the potential projects and improvements within that. Our next slide shows just a brief breakdown and table. Primarily, the funding in the plan could be utilized for the 41 corridor between Avenue 12 and Avenue 15, potential regional sports complex, as well as other improvements. This very similar is a 25% allocation of the property tax increment over the next 45 years. At full build out, it's anticipated that the development would add $2.05 billion in assessment value. That's in 2018 dollars, and that 25% over the 45 years would equate to approximately $59 million. Very similar, right? There is a maximum allocated the dollar figure that could be allocated of $250 million. As I previously stated, it's not anticipated that the 25% would get to that figure, but if it does, based on development and build out, that 250 is the max permitted. So again, the EIFD law does allow for the issuance of bonds, and in order to do that, this action, you have another action before you. Both these actions, one would be the approval of the resolution of intent for the issuance of bonds, and that item, the issuance of bonds, would come at a later date, probably anticipated sometime in late July. We are recommending that your board approve both the Infrastructure Financing Plan 2018-1 and a resolution of intent on the bonding. I would also like to call out as well for the board's consideration in the proposed resolution before you for consideration, we do call out section 15378B4 of the California Environmental Quality Act, which reference and does not consider this to be a project per that. In addition, we also have section 15262 exempting this action from CEQA. This document does not mandate funding of any project, and it's clear in the resolution that the funding and any dollar spent must not occur until full compliance with California Environmental Quality Act is completed. So I want to make sure that's clear. Also, this increment that we're discussing, right, is for a fully entitled development project. There's no CEQA action outstanding associated with those projects. This increment that we're taking or gathering from is a fully entitled development project that's underway currently and under construction as we speak. With that, we're certainly available for any questions that the board may have at this time.
None. Any from the public? None. What's your pleasure? Oh, I'm sorry. Come on up.
You should heard my bones crack when I stand up.
I thought I heard something. I wasn't sure.
Yeah. My name's Thomas Skinner, 1625 Howard Road. I've been asked to come here today to make a presentation on behalf of the Association Against Faulty Financing. This is addressed to the Public Financing Authority for Tesoro, Viejo, Tesoro. The proposed financing plan, I'm going to try and summarize this because it's kind of a long legal document here, so I'll try and summarize that the best that I can.
Thank you, Tom.
The proposed approval of the financing plan and also the formation of the EFID is a project under CEQA and is not exempt from the need to conduct some form of environmental review because the IFP includes commitments to specific projects which may result in significant impacts on the environment. It meets the definition of a project under CEQA. Those guidelines are not specific categorical statutory exemptions under CEQA for which the county can rely on for the purposes of approval. And that's an important point because we'll discuss that in just a second. Paragraph 5 of the resolution that's before you today vaguely directs the Housing and Community Development Director to file a notice of exemption. But there is no such notice or there's no such exemption for what is being proposed in this before you today. That exemption that you're requesting be filed was not included in your agenda today. It is an action of this board. It would be a violation of the Brown Act should you continue to adopt these resolutions or that specific resolution without providing 72 hours notice in advance on your agenda. I'll skip over court citations here. The approval of the Infrastructure Master Plan, the IFP, or financing plan, is the approval of a discretionary project under CEQA because it commits the county to a particular course of action with respect to specific projects. For example, there were a number of projects, including these three, among other choices that the PFA could make. You probably wouldn't be hearing that from this group. Therefore, the specific facilities listed in are anticipated to be funded solely by the EFID. There's nothing in the infrastructure financing plan that says that the EFID will use any other resources to fund these projects, nor are they dependent on other resources for their completion. The IFP also mentions that the amount of funds available for those three projects will be insufficient and that this board will have to choose among those three specifically identified projects. Because of the nature of the EFID implementation, of the specific facilities, the appropriate section of CEQA is 15378A2, defining the project for which an environmental document is necessary for specific facilities contained in the IFP that must be prepared prior to the IFP and the formation of the EFID being adopted. Relying on the Tesoro Viejo specific plan and environmental document as a demonstration of consistency with the general plan is not supported by the facts, therefore it is flawed. Was that, were you waving me down? Were you waving me down, Mr. Chairman?
No.
Oh,
Just
okay.
need a couple more minutes.
One more, okay.
I'm taking notes and I'm looking at this thing you gave me too, so.
Okay. The adopted land use plans, detailed design descriptions and town center concepts, narrative description of school facilities and parking requirements for the Tesoro Village Town Center and 5 Points Central neighborhood contradict the notion that the regional sports complex could be located in that location as shown on your map 1. There are details within the plan that describe the kinds of facilities that would be allowed, and a sports complex is not contained within them. As to consistency, the Tesoro Viejo specific plan, section 3.3, says this: the Tesoro Viejo development standards shall supersede all provisions, standards, and requirements of the general plan, RAMP, which is the Rio Mesa Area Plan, and the Madera zoning ordinance not consistent with them. If a conflict arises, then the standards contained in the Tesoro Viejo specific plan shall take precedence over the general plan. Tesoro Viejo specific plan 3.4.3 states that it is the intent of the county ultimately to modify its zoning ordinance to reflect the specific provisions of this specific plan. But until that occurs, the specific plan will be the sole source to which reference is made with respect to permitted uses and standards, and any such future changes in the county zoning ordinance will be consistent with the specific plan. Important to note that there are school standards here. Very clearly, the high school is located in the town center, and adjacent to that or high school sports facilities, and that's what they're defined. There's no mention of a regional sports complex. The county's report does not acknowledge the existing environmental analysis being undertaken by the county. There are 2 of them. We talked about earlier the Highway 41 facility, which is Caltrans currently is preparing.
Hey,
Not a draft.
we got this report and you're kind of putting stuff in
All right,
between.
let me get to the last line.
Okay.
All right,
because,
I'll deliver that
we
for
can
you.
see that, but you keep adding your own little editorial to it, and that messes me up on this. I was trying to write notes, so if you can just get that bottom line.
All right, let's get to the bottom line.
Okay.
This group respectfully requests that the board continue this item and conduct some form of environmental review prior to including the above specific projects in the infrastructure financing plan. At the very least, the board and its staff must disclose the CEQA exemption the county proposes to rely on and renotice the hearing in compliance with the Brown Act of CEQA. And that concludes our report, sir.
Dale or Gina, give me some of these answers.
Yes, thank you. I have a few things to say, perhaps in response to the letter, and there may be some others from Matt or others here at the table.
Okay.
Mr. Chairman, I just wanted to ask, is it customary for the board to request the address of the group that's submitting a protest? I noticed Mr. Skinner identified rather vaguely the name of an identity of a group whose identity is unknown, and I wondered if it's typical for the board to ask for an address for the.
He put
For
in
those
his letter,
giving-
I guess it's him because he gave his name and address.
All right,
I just took it as coming from him.
all right,
And that's where it's going to be recorded because that's what he said.
all right, very well. Mr. Chairman, I might just mention that we all received this letter as you did just minutes before the hearing today, and so we've had a chance to glance through the letter, and I think there are a few things that we'd like to say in response.
No, that's what I'd like before we make our decision.
Right. First of all, the letter requests that you defer action and not adopt the resolutions today. And we want you to know, of course, that that is your right and privilege to defer action. You're not being in any way pressured to make any decisions today. If you did defer action, then the consequence of that would be that you would simply need to take action or be given the opportunity to take action at a later date. However, because the way the financing plan works, it captures tax increment on the basis of a fiscal year. The consequence of postponing action today to a later date, which you may do, would then trigger a loss of a full fiscal year's tax increment for purposes of the aggregation of tax increment in the plan. So that would be the consequence. First, I think it's important to say a few things that are obvious that Matt has already mentioned, but in light of this protest letter, it's important to, I think, restate them. One is that the projects that will be creating the tax increment that are addressed in the infrastructure financing plan are projects that have already been approved by this board, projects that have received all discretionary approvals, and projects that will generate the taxes whether or not you approve the financing plan that's before you. So those projects have been subjected to full CEQA analysis, including environmental impact reports, and therefore those projects are going to go forward whether or not this infrastructure financing plan is adopted. So I think it's important for that to be in the record. This plan is at best a funding mechanism and nothing more. As Matt has mentioned earlier, the infrastructure finance plan creates no new taxes, simply diverts taxes that will be generated anyway into a fund that can then be used at a later date at the discretion of this public financing authority to fund one or more lists of infrastructure projects. And those funds, if they weren't diverted into those uses, would be used by the Board of Supervisors for other important government projects. And so in that sense, there's really nothing new happening here because it's the same set of funds. The only question is, what are they going to be used for? The letter that you've received, in which Mr. Skinner has summarized, alleges a Brown Act violation. However, the agenda before you announces that there will be 2 resolutions adopted. The resolutions have been available to the public. They speak for themselves. And so there's nothing in the adoption of those resolutions that is not, accurately summarized in the agenda that's been posted. So I'll have to say we're not understanding the allegation of a Brown Act violation. And we believe, in fact, that that's not the case. Okay. With regard to the complaint that somehow this action avoids proper CEQA analysis, I think our belief is that that's also a poorly taken conclusion, and one that we also disagree with for several reasons. One is there is no guarantee by adopting this financing plan that there'll be a single dollar of tax increment generated. This is all based on projections and estimates that are all driven by factors beyond the control of this board and beyond the control of the Board of Supervisors. They're driven, and so the the success of the plan and the success of the projects to generate the increment may or may not happen. These are all, let's call it a hope and a dream. And if they do happen, great, but they may not happen at all. And that's why this is really nothing more than a financing plan in hopes that the future will generate funds sufficient to create the increment that you've seen outlined in the report. CEQA requires the analysis of things that are called and defined as projects. That's a defined term in CEQA. I'm sorry to be a little long-winded here, but so was Mr. Skinner, and so was the letter. So please excuse me if I just take a
Well,
minute.
we got to get it explained to the
Trying to
public.
create
This is all
trying to
public.
create a decent response for you.
Please.
And things that are defined as projects in the statutes require CEQA analysis. As Matt mentioned, we believe that there's nothing that you're today that amounts to a project. There's no claim, by the way, in the letter that you've received about any potential threat or damage to the physical environment. So I'd like to point out to you that while the letter that Mr. Skinner just summarized is as good as far as it goes, there is no evidence in this letter of any actual damage or threat to the physical environment. I'd like to point that out to you, and I'd like that to be in the record. There is, in the definition of a project, a provision, which Matt has mentioned, which makes it clear that a government financing mechanism like this is not a project, because in and of itself, it does facilitate no change in the physical environment at all. And that's section 15378, section B5 of the CEQA guidelines. There are several projects listed, potential infrastructure projects listed in the infrastructure financing plan. But it's important to point out that the plan does not pretend to mandate that they be constructed at all, or that they be constructed in any particular order, or that they be constructed using financing from this financing mechanism. In fact, the letter erroneously said that the plan identifies only financing from the infrastructure financing plan as the sole source of revenue. That's actually not the case at all. The plan identifies several sources of revenue that could be used to build these projects, one of which, if it's available, could be the tax increment generated through this plan. Even if it were to be determined, however, that this was a project, and again, we don't believe it is for the reasons that have been mentioned. There is an exemption under the CEQA guidelines, which Matt mentioned, section 15262, which says that, which talks about the fact that planning documents in and of themselves, which create no change in the physical environment, are not required to be subjected to a full CEQA analysis. Now, the other thing that's important to point out for the record is this board, acting as the public financing authority, is not the Board of Supervisors. Only the Board of Supervisors can give discretionary approval to projects. And so even if it were true that there's an infrastructure project listed in the IFP, this board, acting as the authority, does not have the power to approve it. That requires action by the Board of Supervisors. And at some later date, as Mr. Skinner mentioned, if there is a need to modify the specific plan policies or the Tesoro Viejo specific plan, that will come before the Board of Supervisors, and that will be handled in the appropriate way. Not here.
Okay.
And so I think that's probably all that I would like to say in response to the letter. I don't know if anybody else here on the table would like to add in. Thank you. Any questions?
Yeah, I just got one. Tom, would you mind coming back up here? I'm just looking at this letter made out to Viejo, how you say it. It says, effectively submitted by Association Against Faulty Financing. There is no identification on that. What is the identification on that? Gotta have this, otherwise I'm throwing it away because nothing.
Well, I'm sorry, what do you mean identification?
That,
What do you mean by identification?
I
I'm
mean,
sorry.
what is the Association Against Financing? A name, address, a phone number?
Okay. I don't know the answer to that. I received this morning. I will find that out and be glad to pass it along
But
to
we gotta
you.
have it because right now, this is anonymous to me. That don't help us make any kind of
It's up
decision.
to you. I don't, I wish I could provide it to you, but I can't because I don't know.
Just could I ask Mr. Skinner a question? So just to be clear, Mr. Skinner, this is an anonymous letter that you've submitted today. You're a spokesman for an anonymous group of people. Is that correct?
As I said when I opened my conversation with you, I was requested to present this to the board today by this group, which I did.
Well, what I'm saying, and maybe the lawyers can back me up on it, this don't mean nothing. I like my daughter may be giving me something and say, hey, Dad, this is Joe Blow's doing this to me. I just, we can't accept something like that. As far as I'm concerned, I don't, Gina, can you answer that? I mean, honestly, this don't mean nothing.
That's generally how anonymous letters are perceived, as if it's anonymous and it doesn't have weight. But if Mr. Skinner doesn't have the contact information, it's also hard to respond to an entity if we don't have their identification. If they're not willing to get their questions addressed directly, then it falls into the anonymous category, which typically boards don't hold a lot of weight because
Okay. I've offered to provide that to you as soon as I can find out what it is.
Okay? As soon as you can, because right now, I'm not gonna make no decision on this myself. I don't know what the other two supervisors, I can't tell. Board members, we're not supervisors of this particular group.
No, I understand.
Mr. Chairman, I would just say, just by way of advice, that I think Mr. Skinner has made clear what the letter is and what it's not, and I think the board is entitled to give it due weight, whatever weight it's deemed to deserve. It is in the record, and even though, based on what you just heard, it may not be worthy of much weight, it is here for your consideration as something given during the
That's all I
public
want to
hearing.
hear. That's all I hear that. A little better off. Okay,
May I ask a question?
yes. Well, no, I'm sorry.
No. Let Max go first.
Huh?
let
No,
Max
Max,
go
oh, go
first.
ahead, Max.
Tom, when did you find out about this meeting? When did you find out that we were going to have this meeting to discuss?
When
this?
did I find out?
Yeah.
I watch all board agendas that come out, so I found out this Saturday morning because it wasn't published before 6
Okay.
o'clock Friday, so.
But the point I'm trying to make is that
Mm.
you received this and, anonymous or whatever. It's kind of strange, you get a letter like this and nobody signs it. You're interpreting your idea of what it says, but there's no backup who you represent.
Well, I'm not interpreting. I may have overstepped when I'm trying to summarize, but that was what I received. I assume it came from an attorney's office. I don't write
Right,
that
all right.
well, so.
Let's take a step further. You heard his, I call them complaints. Is there any valid to some of the things that he implicated, that he said that we were doing, it was incorrect? Or can you
I
say?
think Dale explained
Well,
that.
yeah,
It
Mr.
wasn't.
Mr. Rodriguez, let me just say that we, as I've tried to explain, as your legal counsel and staff, I think we disagree with the claims made in the letter
Okay.
of any illegality and of any attempt to avoid the requirements of CEQA. So I'll say, just in short, based on everything you've heard, we disagree with
Okay.
what's contained in this
All
letter.
right.
Yeah, and I would just piggyback a little bit on that. Nothing, I think, on the staff level and what you've heard from Dale, right? Nothing has changed staff's recommendation before your board for consideration today, and our recommendation of adoption of the infrastructure financing plan and the resolution of intent for bonding.
Supervisor, Board Member Frazier.
Yeah, so most of this one's plan goes towards 41, which is in fact right now going through its CEQA process, right? To clear that environmentally, that would be, we wouldn't be adding to that freeway plan, right? It would be to put in the infrastructure that's being studied.
Correct.
But really, it would come down to the sports facility, but that sports facility would have to go through its own CEQA process if it didn't fit within the plan or the CEQA document for Tesoro. Is that correct?
That is correct, and I just want to point out that I think a key aspect of Your statement is if it doesn't, right?
If it's found that it matches
Yes,
that plan, just as in the meeting before with Riverstone, it has to match with that. If it doesn't, it goes through its own CEQA process, correct? The project
Correct.
itself? Okay.
When did we post these?
So one was posted Friday evening, and the other one, unfortunately, due to glitches, was posted at about 11:59 Friday night.
We also discussed
Yeah, if I,
it at the last.
yeah, if I may, Mr.
board
Chairman.
meeting. Yeah.
Correct. On the board meeting of June 12th, this item was specifically discussed. The presentation and my discussion specifically laid out the fact that this item was going to be heard on June 26th.
So we voted.
Correct.
Hope that answers your question.
Okay, great. Thank you.
Thank you. Okay, public comment, any other? Seeing none, what's your pleasure, board?
Move to approve. 5A and B.
Got a second? Roll call?
Call for the vote. Supervisor Frazier?
Yes.
Supervisor Rodriguez?
Yes.
Supervisor Wheeler?
Yes.
Vote passes 3-0, 2 absent.
Is there any other business that we know of, County Council? I adjourn this meeting. Thank you. Want to do the agenda meeting now? Make it. Going to do an agenda meeting right now.